Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which comes to us from LEXISNEXIS, who are the publishers of many family law titles which they took over from Jordan's, but they're obviously a very substantial publication house. This book is a very important practitioner guide. It's the Court of Protection Practice for the year 2023. It's an annual now. The general consulting editor is Ashton, and the book itself is an important one. It's here. I'll just show it in a minute, but let me give you the title that we've given for our review. The most durable of the Court of Protection Practitioner titles, now in a new and completely updated edition. That's for the year 2023, and I'm glad to say that they've actually got a yearly publication now, which I think makes a lot of sense. Let's have a look at the book. It's a hardback. It's a heavy book too. There we go. There's the spine. The back, there's nothing on it. You can see LEXISNEXIS at the beginning. There is, in fact, at the back a CD, which you can see there. And obviously they do use the back pages very helpfully indeed to give information out, just as we have the calendars in the front. This is very much part of the same series as the Family Court Practice, the Red Book, which I use extensively. This is the main book anyway. Let me show you for protection work. Let me just go to the back. Show you the index. The index is by paragraph numbering, which you can probably see there. The pages are very thin, by the way, in this book. So it's not the. You've got to be a little bit careful because they are quite delicate, if I can put it that way. You need to get used to. It's the same with the Red Book, of course, as well, and of course the White Book. References are to paragraph numbering. That's on the index, so you know where you're coming from with that. And I did find the index extremely helpful. I do have a practice in the Court of Protection, and I found this book very helpful. There's some very useful publications at the back in terms of directories. That's in part 12, I think it is, yes. And then you've got various other bits and pieces. You've got a lot of useful addresses. They're working backwards here, and then you've got various things like, for instance, the international conventions right at the back. Now, if we go from the back, you can see there's some paragraph numbering. You can also see there's shading, and that shading will indicate very clearly which part of the book you want to look at. So if we go to the front, and shading is actually quite important with any of these publications because you've got to try and find the information, and it's sometimes a little bit difficult. The Court of Protection Practice, they do say at the beginning, whilst we take all care to ensure this work is accurate, the authors, editors and publishers will not be liable for any losses that any person or entity may suffer as a result of relying on its contents. So you know where you stand, okay? There's the front page. I have to say that because, I mean, obviously they're a bit concerned. There's the blurb all about the book. Then you can see Ashton mentioned right at the top, and all the other people. These books are a collaboration of effort, like the Red Book and the White Book. These books require a lot of people to give a lot of useful information to build the book up so that it's as accurate as it can be. A lot of these people you will know are extremely experienced people. Then you've got James Munby giving, actually this is a foreword, which was some time ago, 2015, when he was much more active and busy doing his stuff. And very substantially good stuff it was too, although don't believe all the rubbish you read in the newspapers, because some of them were very nasty about him. This is the preface to the first edition, which Ashton wrote. It's a long time ago now, that's 2008. Then we've got an introduction. The introduction is very important. It sets out what's happened in the last couple of editions, and obviously deals with the problems of COVID and beyond. And I think that's quite useful because, like everybody, we've all had to change the way we practice. And obviously the details in the introduction set out what the changes have been and where we've been going with some of the most recent case law. And in fact, the introduction is written by Jonathan Baker. Obviously, Jonathan Baker is, for those who don't know, Right Honourable Lord Justice Baker, so a senior Court of Appeal judge. Now, we've then got the contents section, and that's important too because it sets out the various structures of the book. You've got a total number of 13 main chapters. So it starts off with a narrative, then it goes into the various bits of the jurisdictions. Then right at the back, chapter 14 is the Northern Ireland chapter. So 13 and then chapters, and then on the second page, chapter 14. Then you have after that the various parts which give various pieces of information, such as the procedural guides and then the legislation, forms, precedents, summaries and so forth, which is why there's the CD to go with it. And I'm assuming in due course there will be a digital book, if there isn't already. I'm not sure about what's happened to the digital version, but I would imagine, it doesn't say anything here about it, but I would imagine that's, if it's not already being published, it will be in due course, because things are changing quite quickly. And I say that because there are a lot of changes in the next couple of years about the way we present our cases in court and the linking that we have with digital versions of these main practitioner works. I don't think we're quite as far along the way with the Court of Protection book. Anyway, we've got a list of abbreviations, and I'm spending a bit of time showing the book because I think it's very important to do so. Then you've got the main abbreviations continued, then you've got the list of statutes, and that obviously runs for quite a way. Then there's a table of practice guidance, which we've got. Codes of practice, they are very helpful. Then you get into other types of legislation, that's the EU-derived legislation. Then, of course, the case law. And then after that, we then go into what is described. In fact, we get to the end of the cases first of all. And then we get to, after that, as I say, the pages are very flimsy, so take care with them. They don't rip, fortunately. Part 1 starts off with the contents, and then that deals with the narrative, gives an overview, and then you can see all the way through the various contents of the various chapters. I said there are actually 14 chapters in total. Bearing in mind, I did find it a little confusing because the actual chapters end up with Northern Ireland right at the bottom, okay? So this does cover the other jurisdictions within the 4 nations that make up the United Kingdom. Then, of course, after the contents, which is all part 1, you then go into the guides, the legislation and everything else in part 2, right at the back. But you can see the structure. There's the narrative for chapter 1. And then we go on from there. And you can see the footnoting, and also there are some useful notes that are given, which of course are very helpful sometimes. Bearing in mind, here we go, there's a little note there, you can see that. These notes are invaluable for practitioners. That's why, again, with all of these works, they are really important, because that tells us and explains sometimes, there's another example there, it explains what something means and gives you sometimes a relevant case or reference material. Now, I know most people know that, but some newer practitioners may not be quite so familiar with that. You've also got things like the practice directions, which are also mentioned. Now we'll just put the old CD back in there. Let's put that there for the time being. Just put that at the back. And I'll just put the book there. There's the CD. Now, what do we say about the book? Well, not too much, because obviously a lot of it is about whether you practice in this particular jurisdiction, which I have done. Don't do very much work in it, but I do some. So for lawyers and advisors involved in issues relating to the Court of Protection, the publishing pedigree of this definitive text will be likely to be worthy of note in itself, because the consulting editor, Gordon Ashton, explains in his preface to the very first edition, 2008-9, that people who lack mental capacity prior to that date existed in what he refers to as a legal vacuum, in which the mentally disabled were obliged to exist. I'm glad he said it, because Parliament should have dealt with this, and they still haven't, because they're too busy doing other things which they don't think they don't consider this to be that important. I think it's a very important area, and one that should have been looked at a long time ago, because many people in the courts have got mental illness, health issues and illnesses of some sort. There are many more people than we like to admit who've got big problems, and people generally in Parliament and elsewhere have tried to ignore it and hope it goes away, and it doesn't. It's still there, and there are a lot of problems that eventually come down to us as practitioners to try and deal with and try and handle. And apparently it took at least 20 years and a succession of governments to initiate legislation which would ultimately effect change. Fundamentally, it was a gradual yet dramatic change in the social attitudes which brought about the Mental Capacity Act in 2005. I remember the arguments very well prior to that, and in fact a very substantial number of campaigns by MPs to try and get things changed, and none of it worked. I'm very sad because I know the MPs concerned and I know what they were trying to do. But of course it led, obviously in 2005 and beyond, to the creation of this new court called the Court of Protection. Key development, Ashton points out, provided nominated judges as a best interests approach and a regional presence within this area of law. And I can say that I think that that has worked, because when I have presented cases, I've been glad to have had people who I recognise had some understanding and expertise of this difficult area. Now, fast forward, of course, from then to 2023, and note the publication of this new edition. Also, as the editors note, it considerably reflects the changing society that we have, which has emerged, particularly in attitudes towards disability in its various forms, including mental health. Noting, for example, that societal and political attitudes to disability shifted remarkably during the 20th century, when emphasis on control or defective populations gradually changed for the better into an emphasis on care and citizenship. Glad that that's happened. Not a lefty lawyer in any way, shape or form, because we are practitioners and we deal not with some rubbish that the media come up with, but something very important, which is trying to look after people and get the right results in what are very, very difficult cases. And anyone who's been involved in them, as I have, you know what I'm referring to. These are very hard cases sometimes. But despite, of course, the resulting trends in favour of removing disability barriers and addressing discrimination issues, disabled people, as the editor points out, still experience, quote, disadvantage and stigma in England and Wales. I'm afraid they do. Older people, they add, can also face difficult circumstances in today's Britain, especially those without private pensions. But the most important change, as they observe, is the increasing diversity mirrored by the caseload of the Court of Protection. And if you actually have a look at the list, you'll see what they're talking about and the type of case that is coming before the courts. And it's important to note that the new edition of this definitive work, it's a first-class work, provides invaluable guidance to practitioners, plus, of course, access to all the essential materials needed to practice in the Court of Protection, including standard forms, guidance notes, case summaries, international materials, and, of course, much more. Navigation to is straightforward. As I've indicated, you should be able to find what you're looking for pretty quickly, and you've got the ability with the CD, as it currently stands, to get hold of the precedents. Obviously, in the future, that's going to link much more directly into the internet. But I think it's useful to note the tables that you have, the contents, and of course the more detailed table, plus the minutely detailed details that are set forward. And of course both the pages and the paragraphs are precisely numbered throughout for help. It's always important to remember it's paragraph numbering rather than page numbering that you're looking at. And of course you've also got Scotland and Northern Ireland mentioned, which again I think is helpful, bearing in mind where we have been in the past, because this is a problem which I think calls really for an overall picture of how we're going to deal with these issues throughout the four nations make up the United Kingdom. So therefore let me conclude by saying that for practitioners in what is a complex and sensitive area of law, I agree with that entirely, whether experienced or relatively inexperienced as practitioners, I think you will find that this is a distinguished and authoritative text which will be very helpful for you. Just as I found the same with the Red Book and the White Book. You have to know your way around these books, and it looks dreadfully complicated at the beginning, and then once you've got used to it, it actually all sort of unravels a bit and you begin to see how it works. Obviously it's akin, of course, the Court of Protection practice to the Red Book over there, But I think they're indisputably essential purchases for your practice if you're dealing with this particular area of what is, generally speaking, family law. And it does, of course, overlap, but I still look at it really in terms of the family jurisdiction. Of course, the date of publication is cited at the earlier part of 2023. Let's just have one last look at the book. There's the front. You can see the names of all the people on the back there. A lot of people involved in it, nothing on the back. And then just opening it in the middle, these are the various practice notes. There's a Law Society practice note there. You can see the structure of the book. It's a very heavy book, actually. This is actually the Code of Practice under this is the Mental Capacity Act. You can see how it's structured again. And as I say, one of the useful things, there are lots of, there's an example of the forms, for instance, that you've got. Again, it's a difficult area unless you've either had first-hand experience of it in terms of trying to get a power of attorney or whatever, or you've actually practiced. It can initially look awfully difficult. There we go, lasting powers of attorney. There, you see, it's all set out. It also is a bit daunting if you're looking at it from the beginning, but don't be put off by it. Just as I say with the red book and the white book, once you've got used to this, it's relatively easy to find things. And I'll tell you something else. The judges in the courts, they don't know the way around some of these books either, so don't think you're alone. It's a lot easier than you think, though, because if you've got a problem, ask. Don't hide it, ask. And with those words of wisdom, I'd like to thank Gordon Ashton extremely well for everything he's done. I'm very grateful for the work he's done, and I think that this is an important book for anybody involved in this jurisdiction. And thank you especially to Lexis for continuing to produce it. You make our lives a lot easier. Thank you. Bye-bye.